substantial performance, and the third one would be inferior. Okay? So as the name suggests, right, complete performance. So when a party performs exactly as agreed, there is no question as to whether the contract has been performed, right? And the party's performance is perfect. It is said to be complete. So normally, conditions expressly stated in a contract must fully occur in all aspects of the complete performance, or they have another word which is a strict performance if you read in different materials, right? So any deviation breaches the contract and discharges the party's obligation to the performance. Okay. So can anyone name in right which field usually require uh, you know the contract to meet certain specifications? So usually most of construction contracts, right, require the builder to meet certain specifications. So if the specifications are the conditions, complete performance is required to avoid any material breach, right? And if the conditions are met, then the other party to the contract must then fulfill his or her obligation to pay the builder. However, right, if the builders fails to meet the specifications as the parties to the contract did not expressly make the specification to specifications a condition, then such failure have on other parties obligation to pay gonna have any effect, right? And the answer would be we will link to the second one, which is substantial performance, right? This one is very straightforward, so you don't have to. You can link the name of the type of performance to the meaning and the content of this concept, right? So a party who, in good faith, substantially performs all of the terms of the contract, right, can enforce the contract against the other party under the doctrine of substantial performance, right? And the basic requirements for performance to qualify as substantial performance are have three. They don't have it here. Okay, there are actually three um, requirements, right? So first of all, the party must perform in good faith. Second of all, the performance must not vary greatly from the performance promised in the contract. That's why you can see in the slide, it also called as it also has only minor breach. And the third one, right, the performance must create substantially the same benefit as those promised in the contract. Okay, and of course, the court can decide the performance was substantial on a case-by-case basis, examining all of the facts of any particular situation. So let's look at this example. Let's look at one example. So An electric power company, right? Electric power company, right? EP contracted with a Thống Nhất Railroad, right? Had a contract with Thống Nhất Railroad to transport coal to EP, right? So they need so they need right to EP from their mines in Quảng Ninh. Okay. Right. And the contract require EP to notify Thống Nhất Railroad monthly how many tons of coal, right, it wanted to have shipped the next month. And of course, there's a maximum, right? And it must be below that specified maximum. The Thống Nhất Railroad try to make good faith reasonable efforts to meet the schedule. So the contract also require EP to supply the rail cars. Okay. And when EP did not supply the rail cars, right, Thống Nhất Railroad actually used its own rail car and delivered, right, 80% of the requested coal. So in this situation, the federal court actually held that the delivery of 80%, 4% actually, of the contracted amount constitute substantial performance. Okay, so you have tried your best, good faith, right? And even though the company made some mistake, but you try to accommodate that. So that should be considered as substantial performance. Okay, so this is one of the example of substantial performance. This is actually based on a real case. If you have time, you can read. This is actually Wisconsin electric versus Union Pacific Railroad. Okay, it is in 2009. Okay. So this is the real case. So what is the effect on the duty to perform? So if performance is substantial, then the other party's duty to perform remain absolute, except that the party, of course, can sue for damages due to any the minor, right, deviations. In other words, the parties must continue performing under the contract, right? For example, like making payment to the party who essentially performed. If the performance is not substantial, right, there is a material breach, and the non-breaching party is actually excused from further performance. So, and of course, because the substantial performance is not complete, right, the other party is entitled to damages to compensate for the failure to comply with the contract. And the measure is actually the cost to bring the object of the contract into compliance with its terms if the cost is reasonable under the circumstances. If the cost is unreasonable, then the measure of damages is the difference in value between the performance that was rendered and the performance that could have been rendered if the contract had been performed completely. Okay. The next one would be inferior performance, right? When there is actually a material breach of the contract. What does it mean when we say a breach of the contract, everyone? How to explain that? We studied 4 chapters already, actually 3.5, right? So if someone asks you, oh, what does it mean by a breach of a contract? How would you explain? How would you explain? I say, oh, okay, you study at the law university, law school, right? So what does it mean when we say a breach of contract?
I think a breach of a contract is a violation from one party or maybe two party to a general term in the contract, and the consequence derived from that breach probably seek for damages or the contract become invalid.
Okay, thanks, Phong. All right, we also receive a response from Kiều Long, right? When the party to a contract does not perform his or her obligation under the contract. Yep, right. So briefly, right, a breach of contract is the non-performance of the contractual duty that the contractual parties have, right? So the breach is considered material, right? When performance is not at least substantial. Okay, you can read more at section 241 of the restatement statement of contracts. So, and as we have discussed earlier, when there is a material breach, then the non-breaching party is excused from the performance of the contractual duties. And that party can also sue the breaching party for damages resulting from the breach. Okay. So what is the difference between a material versus a minor breach? If the breach is minor, not material, right, then the non-breaching party's duty to perform can sometimes be suspended until the breach has been remedied. But the duty to perform is not entirely excused, right? So once the minor breach has been cured, then the non-breaching party must resume performance of the contractual obligations. Okay? So now let's look at an example to illustrate that, to clarify that a little bit. So we have a singer, right? Let's say ABC is a singer. A, maybe A, too sure. Sure, sure. A is a singer, right? And his mother passed away. So that's why he donate 500K, right, to a hospital in his hometown to build a woman center, woman, and named after his mother. His mother named, let's see, named the center is B. After several years passed and the the women's center was not built, and therefore A demanded a refund. And the hospital, so he donated the money, right, to the how can I say, let's say the people's committee, right, the people committee, right. And after that he demanded a refund and the people's committee refused, right. He claimed that it had provide a promise to honor his mother, right, in some way, but did not promise to build a women's center, right. And in this case, I actually sued for breach of a contract. So if you can make a decision for this case, what do you think it would be? If you can make a decision for this case, if you were a jury, if you were a judge in Vietnam, if you were a judge, then who do you rule in favor, and what would be your decision? If you can decide this case, what would be your decision?
Nobody?
Okay, so this is very simple, right? So you can determine that the People's Committee's failure to build the Women's Center and name it after A's mother was actually a material breach of the contract. And you can award the 500,000 US dollar in actual damages for the contract breach, right? Because the committees actually did not do anything. And then if if in the US, the jury or the judge can actually can actually award another amount of money because the People's Committee actually guilty of reckless disregard and intentionally acting with malice toward others. Okay, so in short, this is one of an example of the material breach. Right? Right, so this is the summary chart of different types of performance, right? And with the legal consequences equivalent to the type of performance that we have discussed. For Vietnamese law, again, so please read chapter 15, okay, section 7, so section 2. And there slide actually provides some of the articles related to performance of the contract. Okay, maybe let's look at a example. Right, we have studied so many things today, so we have only one chapter left, which I think should not be a problem. Right, so let's look at an example. So JY, okay, was a builder and had contracted with Kenny, right, to construct a house in the countryside for Kenny, right? Countryside. All right, and the specification in the building contract require that they had to use the standard pipe of ABC. Manufacture. Okay. JY, the company builder, actually installed substantially similar pipe, but it was not ABC manufacturer, right? Kenny became aware of the difference, right? And he ordered JY to remove all of the plumbing and replace it with the ABC type. Right, and of course, to do so would have required moving all the finished walls, that actually related to the plumbing. Very expensive and difficult task, right? Plumbing. And the builder the JY actually explained that the plumbing was the same quality, the same appearance, the same value, and cost as ABC manufacturer pipe. Okay. And the money is $3,000, right? Still owned for the work. and Kenny refused to pay that, right? Then JY actually sued Kenny for to compel the payment, right? To get the money. So discuss with your group, right? Discuss with your group and let me know the decision and the remedy. Is it clear, everyone? So what, in other words, if you were a judge to this case, what would be your decision? Okay. Do you have any question for the fact of the case? Okay, so I will put you guys in, let's see, we have 30 today. Sorry, we have 24 today. So I'll put you in 4 groups, okay? It will be automatically assigned. And then you have 30 minutes to think and write a response and submit the response to the e-learning, okay? So I will make a breakdown rooms. Forums. B, I'll let you choose the room then, so you feel comfortable. Right, to make sure that you don't end up in one room like last time, huh? Is this your class or another one? I don't remember. But if all the people jump into one room, I will split you out, right? So to make sure don't do that. Okay, we will have 30 minutes. And please respond to, I will post the link of the discussion. Okay. Okay, so any groups would like to uh, answer first? I have not seen any responses yet. So you just if if you have any problems responding to the post, it could be JY versus Kenny. So if you have any problems, just let me know. Okay. So anyone who can respond, could you please if you click on, I don't know, what do you see? That's why if you click on Jenny versus Kenny, JY versus Kenny, then you click on Phúc Đáp, right? They will let you to respond to all right, no, it doesn't matter. If you cannot, you can privately send me the message. Okay. Kim Phụng and Thùy Trinh, right? Okay. Did I say the name correctly? Thùy Trinh. Okay. So okay, we also have Khánh Linh, Châu Long, Hình Nga. Okay. Châu Khánh Linh, Hình Nga. Okay. Okay, anyone else? So let's wait a little bit to receive all of the responses. Anybody? All right, looks like we don't have any further responses. Okay, so if you look in this case, right, you're gonna see that we are looking at, right, substantial performance, right? So JY had substantially performed the contract, right? Even though it is not it's not considered as complete performance, right? So this is very simple and straightforward. So of course, uh, Kenny will actually own, right, JY a specific amount of money that equivalent to the substantial performance that JY actually performed in the contract, right? Like this is actually a very good example, because without this example, this is simple as similar to a landmark decision, right? Because if the court, right, did not apply the doctrine of substantial performance to disputes involving the breach of contract, right, then the contract can be void, right? So it could be unfair to J and JY, right? And this decision actually contributed to a developing trend toward equity and fairness in those circumstances. I mean, you did something even though it is not 100% as per the agreement of the parties, but right, it does not mean that you did not do anything, right? So today, any unintentional and trivial deviation from the terms of the contract will not prevent its enforcement, but will permit adjustment in the value of its performance, right? As I say, so because maybe the owner, right, Kenny, don't have to pay the whole amount of 3,000 because of the minor deviation, but Kenny still have to pay, right? Because in the case, Kenny refused to pay the whole total amount of money that's still owed for the work. So that's why JY sue Kenny in front of the court. Right. So very, very, very basic and simple one to illustrate substantial performance. Okay. Any question for this one? Right, otherwise, let's move on. Okay, stop here. I will continue with. I take note of the people who of you guys who actually sent me the message responding, right? And then that will be added up at the end for the bonus point of this section. Okay, so we're gonna continue to chapter 5. And please, again, right, I may not say it so many times, which many of you don't like, but please read the Vietnamese law, because otherwise you will get lost in the exam. Okay. Right, so the next one, breach and remedies, right? So we're gonna discuss types of breaches, type of breach and types of remedies. Right? So we have anticipatory, fundamental, substantial, and other types of breaches. The first one, anticipatory. By the name itself, right, we can somehow understand what does it mean by anticipatory. It's from the word anticipate, right? It's from the word anticipate. What does it mean? What does it mean if we use that term, anticipatory? It's in the textbook. Anyone want to answer that question? What do you mean by anticipatory? What do you mean by that? So So anticipatory breach, it means that a breach occurs when one contracting party informs the other that he or she cannot perform his or her contractual duties when due, right? So in this case, the contract will be discharged immediately. It doesn't have to wait until the deadline, right? So the non-breaching party has the right to sue the party who just let them know that they cannot perform the contractual duty when the anticipatory breach occurs, right? We don't have to wait until the performance is due, right? So for example, right, let's look at an example. A and B has a contract with each other, right? A has to deliver 10 kilograms of tuna to B, right? And at 5 p.m. today, right? March 15th, right? 2 p.m., right? And the tuna is in Japan, right? It's from Japan. And then at 2 p.m., A actually told B that, right, there's some problem, right? We cannot import anything until next month, right? So therefore, we don't have to, the contract is discharged immediately, right? So we don't have to wait until 5 p.m. when the performance is due. But the non-breaching party, which is B, has the right to sue A immediately at 2 p.m. when A told B that A cannot deliver the tuna by 5 p.m. March 15th. Okay. And regarding substantial, let's say maybe we will discuss the types of remedies, right? We have monetary damages and equitable remedies, right? Monetary damages, or usually they can call it common law remedies. Okay. So first of all, we have compensatory damages, right? And then we will discuss consequential, liquidated, and nominal, right? What do we mean by compensatory, right? Compensatory means that damages that compensate the non-breaching party for the loss of the bargain, okay? And these damages actually compensate the injured party only for damages actually sustained and proved to have arisen directly from the loss of the bargain caused by the breach of the contract. Right, so they simply replace what was lost because of the wrong and damage. And for this reason, they usually say that make the person whole, right? So they're gonna place the non-breaching party in the same position as if the contract had been performed by restoring the benefit of the bargain. Okay. So if you have the textbook, you can look at the example. Right? This is the example given by the textbook. So the L lab, right, enters into a written contract to employ Wei as a chief operator officer, right? COO, for the companies for 3 years, and the salary is 20 grand per month. Right? After a year at work, right, the L Lab actually informed Wei that her employment is terminated. Right? Her employment is terminated. And this is actually a material breach of contract, right? You sign a contract for 3 years, and then you actually, after a year, you say that it is terminated. So if, right, Wayne is unable to find a comparable job, A can sue L Laboratories and recover the certain amount of money as compensatory damages. Right? How much is that amount of money? If you read the book, you have the answer immediately. Right? The question number one is if Wayne is unable to find a comparable job. And number two, no job at all, right? If after 6 months, Wayne can find a comparable job that pays the same amount of money, 25 grand per month, then how much Wayne can recover from the LLAC? All right. So very, very basic question. So in both cases, the question is how much Wayne can recover as a compensatory damages. Anybody want to try? I know that some of you read the textbook already. Maybe then you can explain to your class. Anyone, please? So if this is an exam, how would you answer? How much is the amount of money that Wayne can recover because her contract was terminated 2 years earlier than uh, expected? Anybody? Okay, maybe you can see more of this later on. Let's get back to. All right, so the amount of compensatory damages depends on the type of contract, which party breach. For special types of contract relating to like sale of a good or construction contract, employment contracts, please read more in the textbook, right? That provides the textbook provides like the explanation and some example to illustrate this concept. Mitigation of damage, right? Mitigation of damages. What does it mean by that? This is a very important one, right? So in most situations, when a breach occurs, The innocent injured party is held a duty to mitigate or to reduce the damages that he or she suffers, right? So, and under this doctrine of mitigation of damages, the duty owed depends on the nature of the contract, right? For example, if you got fired, sorry, if your contract was terminated before time, right? It's like the example we just talked or discussed regarding LLab and Wayne. Then you have to look for the replacement job. You cannot just sit there and say that, oh, you terminated my contract earlier, so that's why you have to pay for everything. Right? The second one that we discussing is um, consequential damages, right? Consequential damages. So a non-breaching party can sometimes recover consequential damages, or they can call it special damages, from the breaching party. And, you know, uh, any foreseeable damages that result from a party's breach of contract are called consequential damages, right? They differ from compensatory damages in that they are caused by special circumstances beyond the contract itself, right? They flow from the consequences or results of the breach, right? For example, when a seller fails to deliver goods, knowing that the buyer is planning to use or resell those goods immediately, the court may award consequential damages for the loss of profits from that planned resale, right? So, for example, A and B had a contract, right? But B to deliver like 10 kilograms of tuna, the one that I gave you before. But then B immediately had the contract to C selling that 10 kilograms of tuna as the higher price, right? So, and A knew that resale plan. So in this case, right, the court may also reward B consequential damages for the loss of profit B can make from the sale with C because of the breach of contract, like fail to deliver, the failure of delivery, the 10 kilograms of tuna from A. Okay, so that is consequential damages. Liquidated damages, or usually if you work for a law firm because you are 4C already, then they usually say it as LD, right? So liquidated damages is what? This is a very typical common law type of damages, right? So this liquidated damages are damages that parties to a contract agree in advance should be paid if the contract is breached, right? So, for example, like A and B have a contract, and they say that okay, a certain dollar amount is to be paid in the event of future default or breach of the contract. The word liquidated means determined, settled, or fixed. So, the question: what is the difference between liquidated damages and penalty? Can anyone point out that? We know, like, especially in Vietnam, like you hear that word a lot. Penalty. If someone violate or breach the contract. So what is the difference between liquidated damages and penalties? Can anyone point that out? What is the purpose of a penalty?
I think the purpose of penalty is to punish people for their wrongdoings and to deter people from committing similar action.
Sorry, can you say it again?
Yes, I think the purpose of penalty is to punish people for their wrongdoings and to deter people from committing similar action.
Good. And how about liquidated damages?
Liquidated damages, I think that its purpose is to like the non-breaching party want to at least get their compensation or to make up for their loss.
Okay. All right. So yes, very good. Thank you. Is it Châu Long? Okay. Châu Long, did you just answer it?
No, it's me, it's Nghe.
Oh yeah. Okay. Sorry. Your voice are very similar when I hear it via the headphones. So okay. So yes. So liquidated damages is actually to, how can I say, to make the innocent party whole, right? So it means that as you say, penalty is to punish the wrongdoer, right? To make sure that they don't, or and to make sure they and other people don't do the same behavior in the future, right? Why liquidated damages is actually to, how can I say, to make, yes, to make the innocent party whole. And liquidated damages are usually enforceable if the amount is reasonable, depending on the circumstances, right? It's not in the punitive nature, right? And in the common law, right, because contract is considered as the private law, right? In Vietnam, the term is a little bit different, right? So they don't penalize anyone, right? Because we are in the same bargaining power. We are people and people, all right? You're not the government or something, right? So if a provision calls for any penalty, then the agreement as to the amount will not be enforced, and the recovery will be limited usually to the actual damages only. Okay, so that is how liquidated damages differ from penalties, right? Thanks, Nghe. Right. So we have only 3 minutes left. So maybe let's look at an example to illustrate this point. Would be a previous one. So, not this point, but what we have studied so far. Right. So Nghe, do you have any thoughts on the example that I gave before, like the LLAB and way? Maybe you can explain that to your classmate if possible.
So regarding the LLAB and way.
Yep.
So it's about compensatory damages, isn't it?
Yep. Do you have the answer?
So for the first scenario, if Wei cannot find a replacement, like another job after the termination employment contract, he or she can sue the LLAB and recover 480K, meaning that 24 months 24 months multiply 20K
Yes.
as
So,
compensatory damages.
yes. So it is the first one, right?
Yes.
So in the first one, because she cannot find a comparable job, right? Then she can recover, right? 24 months multiplied by 20K, right? Which is 480, right? The amount of money, right? So in number 2, after 6 months, she can find a comparable job that pay the same amount of money. How much she can recover?
She will get the amount of money that is equal to the period she not having a job, which is 6 months, meaning that she would have 120K.
Right. So 120. Right. So thanks, Nat. Right. So in this one, you can see that if you read the textbook, I don't know which version that you might have, right? So there is a typo in a mistake, right? So they actually use 16 months, but the right number would be 6 months because that is the number of months that she did not have a job, right? And the company had to compensate for that, not the 18 months when she actually got paid 20K per month already. Good. So I think let's stop for now. Right. What number is this?
Miss, I have a question.
Yes, sure. Go ahead.
Regarding the case between JY and Kenny. That is substantial performance and material performance. Oh, I'm sorry, inferior performance.
Substantial performance and what?
And inferior performance.
Yes, go ahead.
So our group's answer is that based on inferior performance principle, JY cannot sue Kenny, but Kenny can sue JY for material breach. Would it be possible for us to argue if the requirement of replacing standard pipe from ABC manufacturer is the material term in the contract between JY and Kenny?
I understand. Yep. I like personally, I think that if I want something, then that should be considered as material, right? Or condition precedent of the case, right? However, this is actually based on, you can read more of this case, right? This is based on the real case. I just simplify that, right? So the case, this is one of the landmark of contract law, right? Jacob and Young versus Kent. This is in 1921. Okay, so if you say that, if because you know this is it is the one saying that the pipe that they are using is actually the same quality, the same appearance, the same value, and the same cost. So that's why the court is more leaning toward, the one saying that substantial performance instead of material breach, right? Because you would be the other way around, right? You look at this like that. So because they say, if you read the judgment, right, by the judge, by Justice Cardozo, you're gonna see they say that the court never say that the one who makes a contract feels the measure of his duty by less than full performance, right? They say, however, an omission, both trivial and innocent, will sometimes be atoned, right? Can be compensated by allowance of the resulting damages and will not always the breach of condition. So that's why that's what they say. Right, so you can read more of that case to answer that question. I personally would take it like I would accept your answer, but if you would like to have the concrete answer based on the real case, then have a look at that case first, and if you have any question, we can discuss further. Is it okay, Nghe?
Okay, I understand. Thank you.
Thank you very much. It's always a pleasure to teach the class as you participated. Okay, good. So for today's class, let's give, even though Nghe had two good answers at the end of the class, but looks like she answered more and have good answer too. So the bonus points will go to Phụng and Châu Long today. Okay, so thanks Khánh Linh, Trang, Trinh or Trang, I don't know, right? Thùy Trang or Thùy Trinh, something like that, for participation in the discussion. Okay, and please, I also told you guys that besides the quality of the answers, also the number of the answers would be taken into consideration, right? So thank you. Have a good evening, and I'll see you guys on Thursday. If you have any question, again, feel free to email me because we're having the midterm on Friday. So if you have any issues related to the material, then just shoot me an email. If there's anything unclear, I can explain, or I will give you more cases to read. Okay. All right. Thank you, guys.